In the event that such outside information comes to your attention, it is important that you tell me or a member of my staff so that I can determine what further action is necessary to ensure the fairness of the trial. The court and parties rely upon your good faith and the fact that you have been sworn to comply with the instructions of the court so that both sides may receive a fair trial. Because this instruction is so important, it is my duty to remind you of it at the end of each day's proceedings. Since you are the sole judges of the facts, you must pay close attention to the testimony. It's important that you carry with you to the jury room not only a clear recollection of what the testimony was, but also a recollection of the manner in which it was given. It will be your duty to pay careful attention to all of the testimony. If you're unable to hear any witness, I ask that you indicate this to me by raising your hand so that I may instruct the witness to speak louder and/or more clearly. As jurors, you will be required to pass upon all questions of fact, including the credibility or believability of the witnesses. If you're not permitted to visit the scene of the alleged incident or to do your own research or otherwise conduct your own investigation, your verdict must be based solely on the evidence introduced in this courtroom. Jurors are not permitted to take notes. Experience has shown that note-taking is distracting. It's better to depend upon the combined recollection of all of the jurors than upon notes taken by one or more of them. At the conclusion of the testimony, the attorneys will speak to you once again in summation. At that time, they will present to you their final arguments based upon their respective recollection of the evidence. Again, this is not evidence, but their recollection as to the evidence. It is your recollection as to the evidence presented that is controlling. Following summations, you will receive your final instructions on the law from me, and you will then retire to consider your verdict. You're not to form or express an opinion on this case, but to keep an open mind until you've heard all the testimony, have heard summations, and have had the benefit of my instructions as to the applicable law, and have been instructed to begin your deliberations. It is your duty to weigh the evidence calmly and without bias, passion, prejudice, or sympathy, and to decide the issues upon the merits. You, as jurors, should find your facts from the evidence adduced during the trial. Evidence may be either direct or circumstantial. Direct evidence means evidence that directly proves a fact without an inference and which, in itself, if true, conclusively establishes that fact. On the other hand, circumstantial evidence means evidence that proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. It's not necessary facts be proven by direct evidence. They may be proved by direct evidence or circumstantial evidence, or by a combination of direct and circumstantial evidence. Both direct and circumstantial evidence are acceptable as a means of proof. Indeed, in many cases, circumstantial evidence may be more certain, satisfying, and persuasive than direct evidence. In any event, both circumstantial and direct evidence must be scrutinized and evaluated carefully. A conviction may be based on direct evidence alone, circumstantial evidence alone, or a combination of direct evidence and circumstantial evidence, provided, of course, that it convinces you of a defendant's guilt beyond a reasonable doubt. Conversely, if direct or circumstantial evidence gives rise to a reasonable doubt in your minds as to the defendant's guilt, then the defendant must be found not guilty. A simple illustration may be helpful. The following is one set of possible illustrations. The problem is proving that it snowed last night. Direct evidence would be testimony indicating that the witness observed snow falling during the night. Circumstantial evidence would be testimony indicating that there was no snow on the ground before the witness went to sleep, but when he or she arose in the morning, it was not snowing, but the ground was snow-covered. The former directly goes to prove the fact that snow fell during the night, while the latter establishes facts from which the inference that it snowed during the night can be drawn. As the judges of the facts, you are to determine the credibility of the witnesses, and in determining whether a witness is worthy of belief and therefore credible, you may take into consideration the appearance and demeanor of the witness, the manner in which he or she may testify, the witness's interest in the outcome of the trial, if any, his or her means of obtaining knowledge of the facts, the witness's power of discernment, meaning their judgment, their understanding, his or her ability to reason, observe, recollect, and relate, the possible bias, if any, in favor of the side for whom the witness is testifying, the extent to which, if at all, each witness is either corroborated or contradicted, supported or discredited by other evidence, whether the witness testified with an intent to deceive you, the reasonableness or unreasonableness of the testimony the witness has given, whether the witness made any inconsistent or contradictory statements, and any and all other matters in the evidence which serve to support or discredit his or her testimony to you. During your deliberations, you may ask what is the more reasonable, the more probable, or the more logical version. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause you to discredit such testimony. Two or more persons witnessing an incident may see or hear it differently. An innocent misrecollection, like failure of recollection, is not an uncommon experience in weighing the effect of a discrepancy. Consider whether it pertains to a matter of importance or an unimportant detail, and whether the discrepancy results from an innocent error or willful falsehood. Mr. Creato stands before you on an indictment found by the grand jury charging him with committing the crimes of murder and endangering the welfare of a child. The indictment is not evidence of the defendant's guilt on the charges. An indictment is a step in the procedure to bring the matter before the court and the jury for the jury's ultimate determination as to whether the defendant is guilty or not guilty on the charges stated in it. The defendant has pled not guilty to the charges. The defendant on trial is presumed to be innocent, and unless each and every essential element of the offenses charged are proved beyond a reasonable doubt, the defendant must be found not guilty of that charge. The burden of proving each element of the charge beyond a reasonable doubt rests upon the state, and that burden never shifts to the defendant. It is not the obligation or the duty of the defendant in a criminal case to prove his innocence or to offer any proof relating to his innocence. The prosecution must prove its case by more than a mere preponderance of the evidence, yet not necessarily to an absolute certainty. The state has the burden of proving the defendant guilty beyond a reasonable doubt. Some of you may have served as jurors in civil cases where you were told that it is necessary to prove only that a fact is more likely true than not true. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Reasonable doubt is an honest and reasonable uncertainty in your minds about the guilt of the defendant after you have given full and impartial consideration to all of the evidence. A reasonable doubt may arise from the evidence itself or from a lack of evidence. It is a doubt that a reasonable person hearing the same evidence would have. Proof beyond a reasonable doubt is proof, for example, that leaves you firmly convinced of the defendant's guilt. In this world, we know very few things with absolute certainty. In criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crimes charged, you must find him guilty. If, on the other hand, you are not firmly convinced of the defendant's guilt, you must give the defendant the benefit of the doubt and find him not guilty. You will note that a jury of 14 has been drawn in this case. At the conclusion of all the evidence, and at the charge of the court, there will be a random selection in which 2 jurors will be selected to act as alternates. The 12 remaining jurors will then deliberate and return a verdict. At this point, we do not know who the alternates will be and whether or not their services will be utilized. Thus, I direct that all jurors should pay equal attention to the evidence as it is presented and to the court's rulings which are applicable to this case. And with this, members of the jury, we've gone a little past what our normal luncheon break would be, which was 12:30. But as I said to you upstairs, because of scheduling, we're never sure how long it's going to take to get the jury selected. We're happy that we selected it this morning, but this afternoon there's no witnesses that are lined up. So the good news is get an early dismissal today. I'm going to ask that everybody report back promptly at 9 o'clock. The first order of business will be tomorrow morning. The first order of business will be here, the prosecutor's opening statement, and then the defense opening statement if they choose to make such a statement. Remember, and tomorrow we're going to probably also have a shorter day also because of other commitments that I have in the afternoon. But we're going to be going forward with the testimony tomorrow. Remember my admonition, it's very important, especially in this case where I do anticipate there may be some media coverage, that you do not look at any media coverage, any television coverage, any newspaper coverage, any radio coverage. Don't discuss the case with anyone, including your fellow jurors, in the morning when you come in, perhaps on high speed line, if you're with somebody else. You can talk about the Phillies, you can talk about the weather, but you can't talk about the case until you've heard all the evidence and have heard the charge from the court and the final comments from counsel. And with that, I thank everyone again for your willingness to be jurors in this case. I think we have information from most of you, the ones that were with us yesterday, for the few new jurors. We're going to get that information if she has not otherwise gotten, and then you'll be released today. I'll see everybody here. And I'd asked, most of you have been back you were here yesterday, came back today. I always tell people, the first day of the trial, we always find some people misjudge how long it takes to get in the camera. I'm going to ask everybody to make an effort to be here tomorrow at 9 o'clock, so we'll be all teed up and ready to go. With that, have a great afternoon and a great day.
Right.
Everybody be seated. See everybody at 9. Let's see if I can find out for you about that.
I appreciate that.
And for purposes of the meeting, I'm going to try, getting the doors open and everything else, there's issues that I have to deal with. We'll try to get you guys in here a few minutes early so everybody will be set up. We'll be ready to go at 9 o'clock. All right? Great. See everybody?
That's would it be okay if we set everything up for,
Session?
yeah, is that okay?
Absolutely.
Okay, all right, we'll give a call, see if I can get somebody to come over. Thank you.